at the Eastern Cape Division, that's where you started out and that's where you still are, right?
Yes, that's correct.
Okay, since 2012?
Yes.
Okay. When did you start acting at the SCA? Just remind me.
I was appointed from the 1st of June 2020 until the end of May 2021, and then again from the 1st of June of this year, and my appointment is until the 30th of November of this year.
So you are there now?
Correct.
All right. How many terms is that?
I have now completed
In total?
five terms. The next one will be the 6th.
All right. How have you found the experience? Stimulating, I hope?
I have found it very stimulating. I've enjoyed it enormously. The first year was challenging, as you would know, because everything was done virtually. And so we weren't based at the court. Although in the May of 2021, I did go to the court and operated virtually there. But it was very stimulating and very enjoyable. Yeah.
Speaking about virtual hearings, I'm going to make a disclosure. You and Judge President Shenaz Mir at the LCC are the reason the SA was actually able to pull that off, be able to, you convinced me that it was possible to conduct hearings virtually because no one had done it. And then suddenly we heard that there was a judge who had just done motion court of all proceedings on the virtual platform. And then I called you and I did not know you from above. So, and you were brimming with all these ideas. And through your help, our court was able to carry on uninterrupted. Thank you for that. I don't think I've ever thanked you.
So it was a pleasure. I'm glad I could be of help.
Right. How many judgments have you written at the SCA?
I think it's 11, I think, from the previous acting stint. And from this term, there are a few that are at conference stage. I
see that you've also, you have a few articles, published articles under your belt.
Yes, I have.
All right. All right, I think that's it from me. I'll let my colleagues loose upon you.
Thank you. Thank you, Justice Mahar.
Colleagues, do you have questions for this candidate? I've only seen up to Commissioner Nyambi. Delay. Any other hands? Okay. Commissioner Moiman.
Thank you, Deputy Chief Justice. Good afternoon.
Good
Justice
afternoon.
Susan. Just one question from my side. How do you balance transformative justice and good governance displayed through one of your judgment that you refer to as part of your contribution to jurisprudence, Mazoso versus the Minister of Basic Education, against sometimes an outcry that there is judicial activism and judicial overreach premise on the assertion that when the judiciary set aside either executive decision or a legislative decision, it blurs the separation of powers. Thank you, Justice Susan. Thank you, Deputy Chief Justice.
Yes, thank you, Commissioner. I think the Constitution requires transformative justice, and that means that the courts are required to act in accordance with the constitutional imperative. So when one's dealing, as in that instance, with the right to basic education, firstly, the interpretation of that right is to be informed by the concepts broadly of transformative justice. But one's ever mindful of the fact that the courts are not there to either legislate or to determine broad policy questions that fall within the prerogative of the executive. In that particular instance, it involved the assertion of the right to basic education, the provision of school furniture, and so what one was concerned with was how the executive government departments responsible for ensuring that those rights are met could do so. There certainly is scope always to place, in this case, the executive on terms, and I think that was the end result of that case. But it's a constant juggling act, and there are no easy or definitive answers one way or the other. They're usually driven by the facts of the case and the particular circumstances that one's dealing with.
Thank you, Justice Susan. Thank you, Deputy Chief Justice.
Mic is off. Commissioner Nyambi, it's your turn.
Thanks, DCJ. Afternoon, Gratusen. One question from my side. What are the three attributes of a good judge, especially SCA? Probably if we can share with us those that you think you have.
Thank you. Thank you, Commissioner. I would think one of the first for me would be a commitment to hard work, to engaging with the material that's presented. And I don't mean that flippantly. That hard work requires a level of engagement with the case at a particular depth. So that's one of the first things, that one's got to be prepared to really get to grips with the issues and the material that comes before you. I think one of the second attributes is being in a position where you respect your colleagues who are on the panel with you, that you're open to the thinking that emerges in the debate with counsel and with your colleagues, and that you maintain a sense of open and fair engagement with your colleagues. The third is that you are, even if you are not engaged or haven't given the task of writing the judgment, that you are, once the conference has been determined and more or less the outcome is decided and the scribe is busy working on it, that you prepare to offer whatever assistance through the research that you have done in preparation for that. I think those are three things that make it, that make the task of sitting on a panel at the level of the ACA that much easier. Of course, there are other attributes that one should have, but I think from a working point of view, Those are the sorts of things that you need to bring to bear.
Thank you, Judge Hussein.
Thank
Thank you, DCJ.
Thank you, Commissioner Nyambi. Commissioner Case?
Justice Hussein, notwithstanding the fact that the jurisdiction of the Constitutional Court was extended,
Yes.
but the SCA remains the apex court. It must develop common law. It must settle precedent. My question is, in terms of your own experience, are you a judge that is ready for the SCA?
Thank you, Commissioner Nochezi. I believe that I am ready, both in practice and in the time that I've spent on the bench. I've had the benefit of exposure to quite a broad range of work in areas where one would expect that those types of questions come before the Supreme Court of Appeal. I've dealt, for example, with shipping law. I've dealt with environmental law, some intellectual property matters. I have had exposure to local government and to planning law. I've obviously, as a High Court judge, dealt with the areas that are more regulated by the common law, contract and delict and the like. Although I claim no particular expertise in any of those broad areas, I believe that the exposure means that I'm able to deal with those matters. I can come to grips with them. You're quite right that of course the Constitutional Court is the apex court. But the Supreme Court of Appeal has a very particular responsibility in the work that it does, I believe, in ensuring that the broader questions of precedent setting in the wide sweep of the law occurs in a way that is consonant with the constitutional imperatives, and that it can supplement the work of the Constitutional Court. And I would think that from the experience that I've had and my background, that I am able to fulfill that task.
Lastly, I think this is my last question. I've counted not less than 13 judgments you have written in the SCA. I'm not too sure, and
Thank you.
I was unable to count further on your reported judgment as the judge of the High Court. There are many. You agree with me, if or you don't, on this one? My take, or what I want to suggest to you, is that the test or the standard expected of a person who is a candidate for a High Court, where you look onto the potential of the candidate, and a person who is expected or was applying for the SCA, the standard should be different. That person must be an all-rounded judge, must be complete, and that can only be assessed through the judgments that have, that he or she has penned down. Would you agree with me? That's my last question.
Yes. No, I think that that's a fair comment. The criteria for initial judicial appointment is, I would imagine, different to that which would apply when one is appointing to a higher court. And at the end of the day, the best indicator of the capacity of a candidate is from the judgments that have been written. That's one of the most obvious, because that's where judges are ultimately accountable. So I would agree with that assessment.
Thank you, Commissioner Matthews. Commissioner Pillay?
Thank you, DCJ. Good afternoon, Judge Wilson.
Good afternoon.
Judge Wilson, I really just have one question, and it's in relation to your judgment in the Serowitz matter.
Yes.
Now, that's a matter where Ms. Serowitz was poor and unemployed. She was the head of a household. She had in her household her daughter and granddaughter. She entered into a deed of sale for 40,000 rand with Mr. Posthumous. And she borrowed the money and paid the 40,000 rand over. And 4 years after he received the money, Mr. Posthumous was sequestrated.
Yes.
And she never got the property transferred into her name. I think she approached the High Court for assistance, and her real issue was how to get the trustees of the insolvent estate to transfer the property into her name. And what she really wanted to do was to compel the transfer of the property into her name. And I think it came before you and you dismissed the application. And subsequently, and I accept that at this stage, her case was amended slightly in the sense that she relied on some constitutional rights and applied to the Constitutional Court. She appealed against your judgment to the Constitutional Court.
Correct.
What struck me, Judge Wilson, was some of the sentiments that came out of the Constitutional Court judgment. And I just want to read just 2 lines of the judgment to you. The first is in the majority decision of the then Chief Justice. He says, this case is about homelessness and vulnerability. One of the many painful and demeaning experiences that the overwhelming majority of our people had to contend with during the apartheid era was not having a place they could truly call a home, and their vulnerability to the system's over-abiding readiness to evict arbitrarily. And then if one goes to the minority judgment, it's a judgment of Judge Cameron, you see a similar refrain, and what Judge Cameron says is the following. He says, it would be a disgrace to the law if there was no answer to Ms. Sarowitz's plight. The main judgment explains that the essence of a claim, etc., and that a case like this demands a solution from the law. Now, I just wanted to get a sense whether the social justice element, was that plain to you when you heard the matter, and how it is that you responded to that?
Yes. Well, I think that the case when it was argued before me was pursued on a fairly narrow basis. I think in retrospect, I think there's no doubt that it's a matter involving an instance of a vulnerable person facing the possibility of eviction in the way in which it played itself out. But questions around the constitutionality and a direct challenge to Section 21 of the Alienation of Land Act wasn't a matter that came before me. The case, when it came before the Constitutional Court, was in fact quite a different case. Not only was the evidence, there was evidence presented at an appeal level, and the matter was prosecuted on a different basis. I accept, obviously, the result, and I think what the minority judgment points out is that the solution was not necessarily as easy a one, although clearly the majority, the solution was to read into Section 21 certain phrases, to read into the legislation a definition of a vulnerable person and the like. And the majority would have come to a different conclusion. The minority would have come to a different conclusion. I think correctly it ultimately was about the position of a vulnerable person. But if you take a decision, and ultimately the Constitutional Court points out that you are wrong in that decision, that's an opportunity to learn and appreciate the basis I had just recently another instance where the Constitutional Court came to a different conclusion to one that I came to in the Supreme Court of Appeal in the matter of Grobler versus Phillips. Obviously the Constitutional Court is correct. That's the position one adopts. But yes, no, I appreciate that what the case was about ultimately was how the Constitutional Court conceived it.
Thank you, DCJ.
President Betze.
Thank you, Deputy Chief Justice. Good afternoon, Judge Hussain.
Good afternoon, Acting President.
Earlier, you did mention that in every case where you sit, even in instances where the judgment has not been allocated to you, you assist whenever you can, whoever is the scribe.
Yes.
And in your experience at the court, has that kindness when you are described been reciprocated by the other members of the bench?
My experience is yes. Generally, when the panel, is deliberated on the at conference, and you have now go off and start writing your judgment. If there is particular assistance that any one of the panel feels that they can offer, they would do so. That's certainly been my experience.
Yes. One of the comments from Nadel,
Yes.
where they say the SA currently has 4 white men, and we're not certain if his appointment, his being a reference to you, will not lead to over-representation on the SCA bench. How do you respond to that?
I think that the figure is incorrect. There are, in fact, only currently 3 white males serving as permanent judges on the bench of the SCA. And that position, of course, is one that is likely to shift and change over the course of the next short while. I don't believe that appointing me at this stage would result in an over-representation. If I were to be appointed, then there would be 4 white males on the bench presently.
You are, of course, aware that there are many factors that must be carefully considered by the Commission when it comes to the appointment of judges, especially to a national appellate court like the SCA. Apart from experience, industry, scholarship, there are also the constitutional requirements spelled out. I think it's section 174.
Yes.
About gender and race representativity.
Yes.
Considering that the 5 vacancies that we currently have came about because 3 black judges retired, 1 black judge was elevated, and of course 1 white judge who was discharged from active service.
Yes.
What factors do you think or would you like the commission to take into account, insofar as you are concerned, that you think should tip the scales in your favor, considering that there are two other white candidates, male candidates,
Yes.
and two white female candidates?
Yes. Thank you, Justice Petse. I accept that there would be, because of the constitutional requirement for demographic representativity, if you like, and that imperative remains, that there would be limited space within the 5 vacancies that are available. I would suggest that my experience, the breadth of that experience, the extensive commitment to transformation processes, both at the in practice and on the bench, that those would tip the scale. And I say the latter because I think if you look carefully at my CV and the type of work that I've done, I have the institution is what needs to be strengthened, and I have endeavored to do so through a process of training, mentoring, and, if you like, creating opportunities for people to be of their best within the institution. The commitment to the institution has meant that I do like to think not just about the work that I do as a judge. I try to do that to the very best of my ability. But I do constantly think about what the judiciary requires. And that has been... oh dear.
I'm sorry, I forgot to warn you. We were told that there was going to be load shedding around this time, but apparently it takes just about 1 minute to kick in. So let's just hold tight. It will be back on now.
Sorry, yeah. Shall I hold on, I believe?
Yes, please. Oh, there you go.
Okay.
Carry on, please.
Yes, thank you. Thank you, Madam Chairperson. Yes, I was saying that that...
Oh, I'm sorry, Justice Hussain. I think the online
Okay.
colleagues are not connected. Can you just check that?
I can hear you. Okay.
We are connected.
Well, if they can hear us, let's carry on. They don't have to see us.
Okay, thank you. Yes, as I was saying in answer to the question, Justice Pate said that I think what you'll find from my engagement in the profession and my involvement in training and mentoring and activities of that, that I believe in the strengthening, as far as one can, as an individual, the the institution, whether it's in the profession or, in this case now, the judiciary. So I do think about the judiciary constantly, about it, rather than not just only the work that I have to do. It's that process that took me into working, for example, with the judge president of my division around case management, took me during the period in COVID that Justice Meyer referred to think about what it is that we needed to do, and do quite urgently, around facilitating the functioning of the courts. So it's that broader commitment to the institution, I think, which is an additional factor that one can take into account.
Thank you, Judge Hussain. Thank you, DCJ. This is where I leave it.
Commissioner Marumachai?
Thank you very much, Deputy Chief Justice. Good afternoon, Judge.
Good afternoon.
I do note the fact that you stated at the outset that you are not an expert of all these, but you had exposure to them.
Yes.
And when I went through your CV, I realized that one of the areas where you have produced a judgment is actually the interaction or the intersection between pension law and family law. The case of Fritz, I'm not sure if you still remember that case. Fritz versus Fund SA.
Yes,
Work
think
umbrella
funds at
fund.
work, yes.
Yeah, you still remember that case.
I do, yes.
I just want us to deal with that case. At the time when this case is, at the time when you delivered this case, there was a Supreme Court of Appeal case that was penned by President Meyer at the time, Krugel versus Eskom. I'm not sure if you are aware of that. I'm just surprised that based on the facts of this case, that particular judgment was not, because I see that your judgment was delivered a year later, because that judgment came around about 2011. And your judgment, if I can see here, it came around about 2012. And of course, you referred to some of the judgments that are important, Siphelele and Maharaj. And we know from Peter's acting president at the time in Daba, that Siphelele was wrongly decided. I just want to understand, when you are following precedent, and the extent to which you do your research, I know that there might be perhaps maybe the counsel before you might not have argued or referred you to a particular judgment, because I think there's a particular paragraph in your judgment that really is answered by paragraph 11 of President Meyer at the time's judgment. Okay. I just want to understand, when you go through judgment writing and so, the extent of your research, okay, and how you deal with precedent.
All right. No, thank you. One is you never rely entirely on the work that is presented to you by counsel. You have to do your own work. There's no doubt. I don't recall precisely. Almost certainly, if it was not referred to me in argument. If it had been, then I would have dealt with it. No doubt. But there are circumstances, I think, particularly in the High Court, as a judge, when you're working under pressure, that you may well miss a more recent matter. I have had often matters argued before me where quite eminent counsel have argued a matter where they haven't referred to the most recent authority. But where I've been able to find it. If in this instance I missed it, then I must have missed it. I haven't looked again at the case nor considered the judgment, but I accept that must happen occasionally. Yes.
No. I think that is fair enough.
Thank
I just want to ask you then, in relation to the law that was dealt with in that particular case.
Yes.
Obviously, in that case, you had a woman who came and wanted to claim what she thought was a pension interest from the husband at the time. But at least from the facts, it appears as if at the time of the divorce, the husband was not a member of a pension fund, and you proceeded, of course, to correctly dismiss the application. But my point is not there. I just want to understand, in relation to the way in which the pension interest is dealt with in this country and the law relating to it, Section 7, Subsection 7 of the Divorce Act, Section 7, Subsection 8 of the Divorce Act, and how it intersect with the Pension Funds Act. Do you, in your view, think that perhaps women, in particular, in most instances during divorces, are actually being prejudiced when these matters are dealt with? Do you think that the courts are dealing with these cases in the manner in which they should be dealing with them? Thank you.
Thank you. I would say that the scope for prejudice faced by women is significant. I'm not sure that I have, if you like, available to me the means to answer the question as to whether the courts are or are not applying this correctly. That would require a careful look at a whole range of judgments on the issue and an assessment of that. I've not undertaken that exercise. But I would certainly be, I think, conscious of the fact that when it comes to pension interests and intersecting with the position that women find themselves in upon divorce, that there is a great deal of scope for prejudice. Partly that's the reason why the legislature has sought to deal with it in the manner in which it has.
Thank you. My last question, Deputy Chief Justice. Have you ever written a judgment in the Supreme Court of Appeal, and that judgment you receive comments from your colleagues to the extent that it changes the entire judgment, and then the final product, it becomes different from the initial product, and then all the colleagues who are part of the panel agree with you and you release a unanimous judgment? Is that the practice general, where in that court people will be making comments to influence the judgment and ultimately it will be a different judgment?
Yes. Thank you. Well, it's not so much about comments to influence the judgment. The process would be that after the hearing, there would be a conference of the judges, and each of the judges would present how they would see and understand the case and what result they would envisage for the case. So at that, if you like, early conference stage, there would already be an exchange of views that would give the scribe, the person who's to write, an idea of whether the judgment that she or he is going to write is one that will be either a minority or a majority view. It certainly happens that in the process following a conference, further reflection and research and consideration may result in either the scribe or, for that matter, any one of the other judges changing a view that they might have had at the initial conference.
Thank you very much.
Yeah.
Thank you.
The alarm you just had go off, colleagues, was the 40 minutes he was allocated running out. So let's please keep that in mind going forward. Commissioner Matolo-Lebu.
Thank you, Deputy Chief Justice. Good afternoon, Judge.
Good afternoon.
No, mine is just a simple one. I see you have written a lot of articles about transformation. The one that interested me is the ethics as a driver of transformation in the legal profession. And I just want to hear your view, because for me, we are still talking about transformation.
Yeah.
And every day, and we are stagnating, actually, as far as I'm concerned, especially in the bar councils. What do you think should be done, actually, to transform the bar council?
Thank you, Commissioner. I'm not sure that I can comment directly on what should be done in the Bar Council. I'm quite removed from that. I'm certainly conscious of the fact that a lot more needs to be done within the profession, at the bar, or for that matter amongst attorneys, practices to foster transformation, and that we're nowhere near where, if you like, we need to be. So I accept that entirely. The article, the focus was really on how we could marshal a deeper understanding of the ethical obligations of practitioners, and use that, if you like, as a driver for fostering transformation, broad transformation within the profession. As to what needs to be done broadly at the level of the bar, given that that was my professional background, I think high levels of support for new entrants coming in, intensified mentoring and training programs to ensure that new entrants, particularly black and women entrants, get the opportunities to build practices, to allow them to sustain themselves at the bar. I think that's a critical element.
Okay, thank you, Deputy Chief Justice.
Thank you, Commissioner. JP Mlambo.
Thank you very much, DCJ. Good afternoon, Judge Clausen.
Good afternoon, JP Mlambo.
I just need to make one comment first before I ask a clarification question. I want to thank you. I mean, I'm here, I represent other heads of courts. I want to thank you for the instrumentality you introduce in assisting your head of court in the Eastern Cape, especially on the judicial case management front, and the assistance you gave to the DCJ when she was heading the SCA in them moving over virtually. As heads of courts, we welcome assistance like that from judges. So I want to thank you for that.
Thank you.
My question relates to what Commissioner Nojesi asked you. So I'm not sure if I heard what your response was. He posed a question to you that the SCA is an apex court when it comes to the common law. What was your response to that statement?
Thank you, JP Mlambo. I think that what I did indicate is that the Constitutional Court is the apex court, and it is the apex court in relation to all of those matters, including the development of the common law, because that development occurs obviously in the context of what the Constitution requires.
Okay, thank you.
But what I suggested was that the SCA needs to and must play an important role in providing support for the process at the Constitutional Court level.
No, thank you very much.
Thank you.
Thank you, DCJ.
Do we have, Commissioner Rikis? You want a second bite?
Just on this, I actually, I'm not sure whether I qualified that.
Yes.
Every matter now, the SCA, because it has extended, I mean the SCC, it has extended jurisdiction,
Yes.
where, you know, I've raised the constitutional issue, public interest and all those things.
Yes.
But I explained the role of the constitutional, of the SCA, not necessarily saying that it is the final court. I
Yes.
just want to correct if I'm understood wrong in that regard.
Yes. Yes, thank you.
Thank you, Commissioner. Are there any questions from the virtual platform? Commissioner Bernard?
Thank you, DCJ. Judge Goosen, just one, and it's on the matter you referred to, the Grobler versus Phillips.
Yes.
You sort of alluded to the fact that you accept the Constitutional Court position is correct. My question to you is, what was the difference in approach You remember that the magistrate had ordered eviction and then it went through the High Court and the
Yes.
SCA eventually in the Constitutional Court again ordered the eviction. What was the difference in the approach and where did the SCA and the Cape High Court go wrong?
Well, I think that the difference between the two judgments is quite a narrow difference. The Constitutional Court, as I understand its judgment, suggested that I had, for the SCA, perhaps paid undue weight or given undue weight to the expressed wishes of Mrs. Phillips, and that was wished to remain. That was a factor that we took into account at the SCA, and the Constitutional Court placed that in perspective and came to a different result. So there's not a widely divergent difference in approach, as I understand it.
Thank you very much.
Thank you.
Commissioner Bredenbach, you appeared on screen for the first time today. Do you have a question?
Thank you. Second time today. Thank you. My question has been asked already, so I'm covered. Thank you.
Thank you. Justice Hussain, it does appear that we have run out of questions for you. We've reached the end of your interview. Thank you so much for making the time to join us this afternoon. You're excused. Go well.
Thank you very much for having me. Thank you. Should I put this on?
Are you ready?
Yes,
All right.
Yes, I am.
Good
Sorry,
afternoon.
Thank you, Judge.
How are you?
I'm very well, thank you, Judge Maya. Yourself?
I'm fine, thanks. Good to see you after a long time.
Thank you.
You were interviewed by this commission not so long ago, and we have the record. It was a thorough interview, so I'm not going to lead you on your list of achievements. All I will ask is, what have you been doing with yourself since then that you think might warrant inclusion in your CV?
Judge Meyer, it was in fact on the 14th of April 2021. Since then, I've just been doing my normal duties in the KwaZulu-Natal court. I had been asked, and that's probably what you might be referring to, prior to my previous interview, by the Deputy Judge President to preside in the matter of the state versus former President Zuma. And I'm the judge in that matter. And I think the rest is an issue of public record that a plea has been raised, which I dealt with, and then also applications for leave to appeal thereafter, petitions to the Supreme Court of Appeal, a reconsideration application by yourself, and then the matter has been referred to an application was made to the Constitutional Court, and I gather, although I haven't seen it yet, that a judgment or order was issued last, I think, Wednesday, dealing with that, but I haven't seen it, so I wouldn't like to simply quote on what I've read from the press. But that has been the, if you like, the main sort of issue of public interest, I suppose, that I've been involved in, apart from various other duties in KwaZulu-Natal.
All right. Oh, there is just one other aspect. You have made a submission in your application form on the rather unfortunate exchange you had with former Chief Justice Mogoeng during the interview we just spoke about. I don't know if you'd like an opportunity to set the record straight from your side now that you are here. If you don't wish to do that, it is your prerogative.
Judge Meyer, maybe I should, in the interest just of transparency and fullness, say that I consider it to be a very unfortunate incident. I was very saddened, and when I left the venue, felt gutted by the criticisms that had been expressed of me. I had been forewarned with documentation which I circulated with my covering letter to the Judicial Service Commission for this interview today. I provided those documents which alerted me to the fact that I was going to be questioned on cost-cutting measures which was sought to have been introduced by the Circular 15 of 2016. And when I answered those, that being the issue on which I prepared, I was told that that was dealing with the merits and that the former Chief Justice's concerns related to the manner in which he said I addressed him. And he then also went further to say that he wondered how I ever was made a judge, how I dealt with litigants and people who appear before me. And because I'd been forewarned to deal with the issue of cost-cutting measures, I did not have the transcript of the particular meeting to which he referred. I didn't have a formal version thereof, transcribed and certified by a transcriber. If I had been forewarned about it, then I would have produced that at the hearing, which was or the interview on the 14th of April 2021. I have now, and I hope that it's been circulated to all commissioners, obtained that transcript. It is circulated with a covering letter. I have also circulated the audio clip of that entire judges' meeting, because fortunately that meeting had been recorded. I was not aware of it at the time that it was recorded, but it was. And I don't want to spend negative energy on this issue. It's something that happened. I think it was unjustified with respect, but commissioners can look at it. They can read the transcript of that judges' meeting, which was said to have caused so much offense. They can listen to the recording And if they do, or would be so inclined, I think they would have picked up that there was no raising of voices or anything. I was speaking as one of the senior members of the KwaZulu-Natal bench as I'm speaking at the moment. But as I say, it happened. I was gutted by what was said. If litigants or people in the legal profession Google my name, they come up with that interview and the lashing that I received. That is going to be a historical fact that's going to remain with me for the rest of my life. But we must move on. I don't want to harp back on it. I think there are more important things. I see my role still as making a contribution to the judiciary, to jurisprudence in this country, hopefully, and I don't want to be sidetracked by what happened. It's behind me. You know, so many people, when I walked out of that venue, my phone was ringing non-stop, and judges from the Constitutional Court to the Supreme Court of Appeal to other provinces were all phoning me and saying, "But what is he talking about? We know you." And practitioners were saying, "You must sue for defamation." You know, where's that going to get us? That's been my attitude since then. I don't think that will be in the interest of the judiciary. But please, I don't really want to dwell on it anymore. It's a very, very unpleasant episode in my life. It's something that I relive quite often in the early hours of the morning. I won't deny it, but I suppose it comes with the territory. And thank you for the opportunity to comment on it. I'm not wanting to score points out of it or anything like that. I'm simply wanting to put the record straight, and I'm happy to be judged by what commissioners think of the transcript and the recording that I've circulated. Thank you.
Thank you very much, Judge Kun, for that explanation. Well, for what it may be worth, I do want to place it on record that those of you who worked with you at the SCA did not know, do not know the person that was described here during those proceedings. Throughout your acting stint at the Supreme Court of Appeal, you always behave impeccably as any good judge would. So, thank you. I will hand over to my colleagues if they have any questions for you. Questions, colleagues? Commissioner Nyambi? President Petse, Commissioner Nyambi.
Well, thanks, DCJ. Afternoon, Judge Kun.
Good afternoon.
From the last time you were interviewed, as you might have reflected or gone through what happened then, besides the issue that you have touched, any other thing that you think with hindsight you might have put it differently or you want to bring to attention in terms of reflection of the past interviews, besides the issue of that unfortunate incident that we must seriously consider this time around?
No, I don't think there's anything. If you read the transcript of the last interview, the one of the 14th of April, I am very happy with the way that questions were posed to me. I was very happy with what was being sought to be explored. The transcript is not a perfect transcript. There are some errors, but I don't think I could have wished for a different interview up to the point near the end when Chief Justice Mocheng then took over the questioning. Is that what you're wanting me to deal with?
No, it was about any other thing that is significant as we have done the reflection about the past interview, besides the unfortunate incident that you might want to bring to our attention now so that we can seriously consider you as a possible candidate to go to the SCA.
I see. Well, since the last interview, obviously I have now spent another 18 months as a puisne judge. At the end of this month, 31st of October 2022, I will complete 16 years as a puisne judge. I've always enjoyed the study of law. There was a bit of a hiccup with the incident that occurred, and it made me considering all kinds of options, possibly even leaving the judiciary altogether, and employing my skills to the extent that I have them elsewhere. But I enjoy being a judge. I have, however, reached the point, but that isn't really something new. It also prevailed in April of 2021, that I think I've grown to a stage where I'm looking for new challenges, and that's really why I'm looking at the position on the Supreme Court of Appeal. As an appeal court, I think I've got the experience that I can contribute. I can contribute the other issues that are detailed in the transcript of the previous interview, and it's going to be, although it might sound self-satisfying, it isn't. Well, I suppose it is, but I foresee for myself more professional growth in an appeal court setting where I've been in a trial court setting for 16 years. And I'm now 63. My exit date will be the 14th of September 2029. So that gives me just, 7 years.
Thanks. My last question, Judge Good. What event or incident or judgment in the recent years will rank highest in your view as having contributed the most in the strengthening or development of the South African jurisprudence?
Sure, that's quite a, if I have to cast my mind back, it's perhaps not in recent years, and it's perhaps not a judgment so much that I gave, but a judgment that I was involved in, and from which there have been interesting developments. And it's in the list of judgments that I refer to, or the cases. It is the one of ShopRite Checkers and Everfresh Market, Virginia. Now, I'm a little bit hesitant to claim any credit for it, because, it's that judgment, and then also the one in KwaZulu-Natal Joint Liaison Committee versus the MEC of the Department of Education. And I'm hesitant to claim it as a contribution on my part, because it started off as a fairly simple issue before me, presented as a contractual claim as to what is meant by the word approximate. And I had made certain findings that it was too vague to be enforced at a purely contractual level, and it met with a similar fate at the Supreme Court of Appeal level. But then it had made its way to the Constitutional Court. And the Constitutional Court then dealt with the issue. The majority judgment, separate concurring, majority judgment by Cameron J., separate concurring judgment by Fruneman J. My approach had been one more consistent with what Zondo, then J., Mocheng CJ, and also Jafta J had opined or concluded. But the point that I'm wanting to make is, although it was presented as a contractual matter, how it ended up was that it was treated as a public law matter, although it wasn't a review, which was quite a step forward. And there's a very interesting article, and that's why I say I view this as quite an important or an interesting development, because there was a very interesting article by a contemporary of mine at university, that's Professor Hoekstra, called The Enforcement of an Official Promise, Form, Substance, and the Constitutional Court, where she discusses the judgment in KwaZulu-Natal Joint Liaison Committee and then also contrasts it to the judgment in Kurland. Now, the interest arises from the fact, for me, arises from the fact that in KwaZulu-Natal Joint Liaison Committee, Cameron and Fruneman were really prepared to go outside the pleadings to achieve a result which they believe constitutionally was required. Whereas in the Kurland matter, they were more insistent, because they form part of the opposite side. They were more insistent that if something wasn't claimed by way of pleadings, that one couldn't deal with it. In the context of what we're discussing at the moment, my present statement to you is probably too superficial to perhaps emphasize the point that I'm wanting to make. I don't want to go into the facts of each case because we have limited time, but it's that kind of proactiveness, if you like, not being bound by pleadings, which is quite a debate, I think, in our law, which will need to be addressed. Obviously, I hear and I live with and I deal and I unreservedly accept what the Constitutional Court had decided, for example, in KwaZulu-Natal Joint Liaison Committee. But it's an interesting point, this, of to what extent in future litigation the pleadings are always going to be taken as the be-all and end-all of what the parameters of the parties' dispute would be. In KwaZulu-Natal Joint Liaison Committee, you might recall that the parties were encouraged, directed to negotiate, to try and agree on what is meant by an approximate value, and failing such agreement, the matter had to be referred back to the trial court, me. And I am not sure how I would have resolved it, but I think fortunately it was settled.
Thank you, Judge Kuhn. Thank you, DCJ.
Thank you, Commissioner Nyangwe. President Petty.
Thank you, DCJ. Good afternoon, Judge Kuhn.
Good afternoon, Judge Petze.
From the feedback that we received from legal bodies, there is one from the Black Lawyers Association, which would have been furnished to you in the ordinary course.
Yes.
The last paragraph says, his judgments, that being a reference to you, do not demonstrate a deeper understanding of the constitutional law, which we believe is needed at the SCA. I raised that with you in the context of the judgment of Mahlangu versus the Minister of Police, where your judgment that the SCA was overturned by the Court. And the proposition that I want to put to you is that that case implicated two important rights entrenched in the Bill of Rights, that is personal freedom, right to be free from all forms of violence and not to be tortured in any way, which were lost on you when you wrote your judgment, because the High Court had found that Mr. Mahlangu and the other appellant were tortured by the police to extract a confession from them. That confession was used by the police to oppose bail on the basis that they had a conclusive case against the appellants who were charged with murder, resulting in them being detained for up to 10 months. And the effect of your judgment overturned by the Concord was that they had no claim against the Minister of Police beyond 7 days, the initial 7 days of their detention. Would you like to respond to that?
Yes, thank you. Obviously, I've seen the statement in the, I think it's the second letter from the BLA. It didn't identify any particular judgment, so I wasn't able to really make much of it. But I'll deal with the Mhlanga judgment. The Mhlanga judgment, you obviously recall because you were the senior presiding judge on that matter. It had come from the trial court. It went where the decision was given. It went to a full court, Collipan J and two others I can't remember, that also denied, albeit for different reasons, a remedy. So when we dealt with it, it was really the third court that was dealing with it. 4 judges already previously effectively haven't denied him that right or the compensation. The SCA was split. I wrote the judgment, Kachalia JA and Dolamo AJA concurring in my judgment, and Van der Merwe JA wrote a separate judgment, and you wrote also a separate dissenting judgment. The issue of, let me say also that I unreservedly accept that there are constitutional rights involved, but the matter really turned, and I think it was following a judgment of the I think it was Kruger, if I remember correctly, but the issue became one of causation. I unreservedly also accept in that matter there was the issue of torture, and I would not deny a remedy to the person subject to the torture in a claim against his torturers, the police and the Minister of Police. What my concern was, and that of the judges who, and I can only speak for them, who concurred with my judgment, was the question of causation thereafter. That a limit must be reached on where the liability of the Minister of Police would terminate. Doesn't mean that after that there's not a remedy, for example, against the Minister of Justice. You will also recall that one of the issues arising in that matter was the problems that are experienced with so-called reception courts on bail being granted. So in a nutshell, if I can answer it, or if I can oversimplify it, and please forgive me if I do oversimplify it, torture, the detention by the police, the initial lying off that there's a confession, up to that stage, clearly there's an action against the police. I think what I was trying to grapple with, and that I was trying to deal with in my judgment, was the question of causation. That when a point is reached where there's a court that should entertain and adjudicate a bail application, that the liability does not lie with the Minister of Police anymore. I accept, however, that on that causation element, certainly the Constitutional Court came to a different conclusion, and I unreservedly accept that. But I certainly did not make light of, and I now cannot recall, but I think, no, we might have left it out. No, I think we did include it. There was in fact a very useful reference to the treatise on, international treatise on torture being applied in matters where accused are being detained in custody, which Mr. Justice Kachalia brought to my attention. And either it was part of the draft that I prepared and remained there, or I might have taken it out. But if I may just refer to that fact that I was very alive to those dangers, and I certainly am alive to the constitutional value of it, and I would certainly, if there was any claim for pain and suffering, loss of amenities, contumelia, etc., flowing from the torture, that would clearly found an action for damages against the police.
Well, the claim was about unlawful detention.
Yes.
And you found against the appellant.
Yes.
And the minority judgments came to a different conclusion.
Yes, that is correct. It was on the question of who caused that further detention. Was there an interruption of the initial cause caused by the arrest by the police, or should there have been a determined judgment being issued by a court of law, and not just these detention courts, no, not reception courts, where matters are simply adjourned.
You are aware, of course, that there are many factors that the Commission should carefully consider when it comes to the appointment of judges, and bearing the constitutional imperative in terms of Section 174(2) to promote, as far as it is possible, a bench that is broadly representative of gender and race. What factors would you like the Commission to take into account in relation to you that you think should tip the scales in your favor, bearing in mind that we have 5 white candidates, 3 males and 2 females?
Yes, that constitutional imperative is obviously, it's always a difficult issue. It is something which this Commission must address. I am obviously a white male. That is a fact. 174(2), as I said during my previous interview, I do not think introduces a sort of an employment equity type analysis at all costs. From the permanent appointments that I understand on the SCA at the moment, I think there are 21. That's the figure that was mentioned in the report backs, of whom 11 are women. And I was told earlier today that of the 10 males, 3 are white, and then obviously you've just referred to the statistics on the current applicants that you are interviewing for these 5 positions. I cannot get around the reality that I'm a male and that I'm a white male, and I don't profess or try to do so. I certainly, however, try to give expression to the sentiments and the thinking, I think, behind 174(2) of making my skills and my ability, to the extent that I'm able to make any contributions, available to all colleagues, And that's always been my attitude, whether in the time that I've been privileged to serve at the Supreme Court of Appeal or on the KwaZulu-Natal bench, and even prior to that, as a member of the bar in KZN for over 18 years, 8 of them as a senior counsel. I think I can only offer that openness, that ability to assist as a contribution to what I think the fathers of the Constitution sought to achieve by Section 174(2). I am honored to have, certainly from my days at the bar, pupils, one who in fact gave a nomination letter supporting the present application, who were my pupils, subsequent colleagues, who have since taken silk, both of them, and who have even also acted as acting judges with me. So I try and make my contribution in that context.
Thank you. And lastly, and on a lighter note, you say at page 22 of your documentation, open quote, although there are a number of other former attorneys presently serving as judges of appeal on the bench of the Supreme Court of Appeal, to the best of my knowledge, I shall be the only one who has qualified in addition as a notary public and conveyancer, with the exception of one judge whom you have mentioned.
Yes.
Obviously, leaving other colleagues like myself out of the equation, because I practice as an attorney, notary public, and conveyancer for 24 years.
Judge Petse, my sincerest apologies. I made those inquiries with a member of the SCA who said to me that, no, there are no conveyancers and notary publics here. But, well, let me not refer to the particular member that I mentioned there, but I don't think she'll mind. Justice Molamela, who qualified us both. But I'm deeply sorry that I didn't give recognition to your additional qualifications. I certainly recall you.
Thank you.
From the
Thank
days.
you, Justice Kuhn, you are forgiven.
Thank you.
Okay.
Thank you, DCJ.
Thanks, President. Commissioner Notice?
Thank you, Mr. Chair. Good afternoon. Yes.
Good afternoon.
Thank you, Judge Kwan. I've looked onto your cases. Have you ever been called upon to deal with a case that requires the application of the customary law, and you had to, in accordance with Section 211, sub 3, apply the customary law? You are obliged to do so.
Yes. No, I haven't, unfortunately so. I've read with much interest a little booklet that was prepared by our DCJ, Madondo, on traditional courts. I have followed the progress of the present bill with some interest, the exclusionary provision, and I'm waiting for it to go through the National Council of Provinces and for signature by the President. But that's on the traditional courts. But traditional or customary law as such, certainly in the High Court, I haven't had an opportunity to do that, no.
I'm asking you that question simply because, as a senior judge in the division, you are one of those judges who, essentially in this area of the law, and especially in view of the Constitution, that demand for the application of customary law where it applies, gives that obligation.
Yes.
You had an opportunity to do so if you wanted to, as a senior judge.
I don't, as a general rule, deal with allocation or get to allocate cases. They get dealt with by our, at the present, acting judge president, or then a deputy judge president. So those haven't been allocated to me. I generally just deal with what comes before me. In recent times, I think the most significant one, to the extent that it involves an application of some customary law, has involved the wills and the succession to the late king. And that was dealt with by, it was taken control of and dealt with by the acting judge president.
Yeah. I'm asking you this question for two reasons. One, at the SCA, in my view, one of the demands for a person who's appointed there is that he must be an all-rounded judge. So if you do not have, you have admittedly an area such as customary law, you have no exposure. That's a concern to me. The second reasons for this question is that there is criticism. Recently listened to a debate in which Judge Hlophe and others were discussing the same, and even in the JSC this has often been coming up. There is a criticism that courts do not want to or are reluctant to apply the customary law as a system of the law. So those are the two reasons why I'm asking this question.
Yes, starting with the latter first, I would have no reluctance to invoke it and deal with it, and I would love an opportunity to get my teeth into something like that. But it hasn't been allocated to me, and that's all I can say. I would relish the opportunity if it could be allocated to me.
Yeah.
So I can deal with it.
Lastly, I see you attached the judgment, the judgment that concerns your rulings in the matter of State versus Jacob Zuma.
Yeah.
But the last one is the one that I want to ask about is your ruling regarding really adjournment of that matter,
Yes.
which is attached. What is the significance of attaching that judgment? How does it assist us in dealing with your application, or what point do you want to establish by attaching that judgment, which purely related to your ruling regarding an adjournment of the matter?
Yes. Can I answer it like this? The questionnaire requires 3 judgments to be attached. I had Supreme Court of Appeal judgments, and then I thought, no, I must attach a more recent judgment and something that's topical. And one of the bigger judgments, or more significant judgments perhaps in the interim, has been that relating to Thales and Mr. Zuma. And you are undoubtedly aware that a lot of pressure is brought to bear, certainly in the court of public opinion, not that I am governed by the court of public opinion at all, by delays that ensue and of appeals taking time. And I was really annexing this judgment to show how I have an appreciation for how the law has changed in regard to what principles govern appeals in a matter of this nature and the delays that ensue, so that there's a better understanding of it. The previous sort of regime prior to what was introduced, well, when I say previous regime, with Western Areas, S versus Western Areas, and the judgment of Howie P. changed significantly with the provisions of the Superior Courts Act 10 of 2013 taking effect and its definition of appeals. And the area is now quite a complex one. Appeals have become quite a hot potato being discussed at times. And I think that what I was trying to demonstrate to you as commissioners was this is not the adjournment wasn't just something that was a convenient thing to grant out of the air. It was a considered judgment in the light of numerous, not always all that clear principles, but which I've tried to set out in the judgment which I've annexed. And I'm hoping that by annexing it, I've demonstrated that ability and that skill to navigate also this area of law, which often might be seen as a neglected area. And it's an area possibly, as I think I might have, I don't know whether I said it in the judgment, but in one of the judgments, that might require some judicial reform at some point. Because it's quite a messy area where what is appeals in a civil context in terms of the Superior Courts Act also come to apply when one gets to stages where there's a consideration or a reconsideration application in a criminal matter, which falls under section 17(2)(f) of the Superior Courts Act, and where the two then merge. So you've got to keep a cool head about things, and that's what I was trying to demonstrate, and I hope I have.
Oh, thank you, Judge Kun. I would have loved to debate with you more, but unfortunately time is against me. Thank you, Mr. Chair.
Thanks, Commissioner Nikis. Commissioner Pillay?
Thank you, DCJ. And perhaps, Judge Kun, I could just start following up on that line of questioning. You're aware of Article 4 of the Code of Conduct that entrenches the principle of judicial independence.
Yes.
And the notes attached to that article, which emphasizes that a judge acts fearlessly according to his or her conscience, and that you're only accountable to the law. You don't pay heed to political parties or pressure groups, etc.
No.
And in your experience, Judge Kun, do you find that most judges around you would adhere to Article 4?
Yes, I think they do. Yes, no, I certainly think they do. And I speaking for myself, I certainly adhere to it unreservedly.
Now, the reason I ask, Judge Kun, because I was interested when I read your application to note that there were two specific instances in your application where you raise your handling of a matter to almost want special points or special recognition for acting impartially. The one is the Clearly matter where you mentioned the fact that this is a minister's wife you were dealing with, and the other is a matter involving the Cape Bar Council and this body. And I think your narrative mentions the fact that it's a demonstration of how independent you are because you acted fearlessly against you gave a judgment fearlessly against the interests of the JSE.
Yeah.
Now, both those instances raised a bit of a concern for me because the two issues which you highlighted and you bring to our attention almost in a bid to get special recognition, or in colloquial terms, brownie points, are really what we expect from judges on a daily basis. I mean, it's a minimum kind of expectation that judges would discharge their obligation and their functions in that manner. So perhaps you just want to explain that.
Yes, no, it's certainly something that follows from Article 4. If the way the form was completed conveys that some special recognition was being sought, then it's created the wrong impression, and I apologize. It's not what was sought to be achieved. It is simply stating that I decided the matter according to my conscience, and Yeah, there it is. It's what I required to do, and I did it.
Just to pick up on that, Judge Cohen, when I read the transcript of your previous interview,
Yes.
and you'll see it at page 258 of the bundle. I'm not sure if your bundle is paginated the same way ours is. But there's
258.
the transcript of your interview right at the end, at paginated page 258.
Yes.
Where you touch on this issue and you say, I granted the application for leave to appeal without reservation to the SCA. All I sought to convey was some judges might, and I'm not saying will, when dealing with a sensitive case like this, possibly have an eye on the future. I have always wanted to be a judge. I was hoping to advance my career as a judge. It's again just tying on to this theme that you seem to indicate that you acted almost in a special manner or in an exceptional manner, unlike other judges, because you approached the matter impartially.
No, there couldn't be anything further from the truth with respect. As I said further on, it was purely at the level that if it was to be held against me, that I've conducted myself as properly and as I should, well then so be it. That's all I was saying. But I was never qualifying my duty.
Then, if I could just finish off this line by taking you to the Zuma judgment, and I just wanted to again understand your reference to the Court of Public Opinion, and how did that feature in your decision, in your Zuma judgment?
It didn't, sorry, I interrupted you.
My question is complete, you may answer.
Thank you. It didn't enter my mind at all. All I was saying is I was asked about why, or what significance the judgment has, why it was annexed. And I annex it, I think, to demonstrate the issues and my reasoning behind the conclusion to which I came. Notwithstanding there being public pressures about why are there all these delays, etc.
Thank you, DCJ. I think I've got time constraints.
Just a quick follow-up on that one.
Commissioner Malema?
We've not been doing that since we started. So. No, Judge, I have a problem because in answering that question, you are the one who just brought the issue of public opinions, that not that I'm influenced by it, but the issue is there, and I was trying to demonstrate that I don't take that into consideration, as if you are expected to take that into consideration. What informs that? Because clearly you are trying to tell us somehow you get influenced by public opinion, because it doesn't arise. No one has raised that matter, including the two-sided cases. You are the one who just bring them to the fore to demonstrate that there is some influence which you are not supposed to get from anywhere. You ought to act independently, fearlessly, without any influence. But through the answering you gave now, clearly you are taking these things into considerations, because no one spoke about such things. You just brought them up on your own.
Yes. I don't take it into account at all. I give my judgment according to the dictates of my conscience. I raise it in the context of the question that was raised as to why I chose this particular judgment to annex as one of the judgments. And all I was seeking to do is to say it demonstrates the principles according to which I decided the matter, according to the dictate of my conscience and to the best of my ability. There are other people, maybe outside there, would call them whatever one wants, court of public opinion, whatever, that might criticize some of the adjournments that I've granted. And all I was saying is, I annex this judgment because it demonstrates, hopefully as part of an educational function to outsiders, what the issues were that I took into account.
I agree with you, Judge. That is the type of the answer we expect from a judge. And don't take it further to the public opinion, because you said, I'm raising this matter because I decided it on the basis of the best of my conscience, and I looked at the facts and I decided. Then you go further to say, despite the fact that there were public opinions and all of that, I still acted. So now you are inviting the public opinion, which we never invited here.
Yes. No. Okay. As I say, I was simply trying to demonstrate why I was annexing this particular judgment.
Thank you, DCJ.
Commissioner Marumafai?
Thank you very much, Deputy Chief Justice. Good afternoon, Judge.
Good afternoon to you.
I want to take you back for a moment, and in your explanation of what you believe the judgment of Mahlangu was about, and in explaining to us your approach in relation to the majority judgment that you gave.
Yes.
And I wanted to debate this with you, but I thought maybe other commissioners will deal with it. And of course, this I tie it with the BLA's comment in relation to their view on you and the constitutional part. And my comment or question is related there too. When I look at your majority judgment, you refer to section 12(1) of the Constitution. I mean, in regard to the facts, of course, but you don't appear to be discussing it. And you refer to it in paragraph 13 of your judgment. And then the minority judgment in paragraph 87 tries to contextualize why that section might be important in this case. And the Constitutional Court actually goes a distance in showing why it is important. And you took the line of causation. And of course, the Constitutional Court, the way I understood the judgment, it tied causation with unlawfulness, hence they went to vicarious liability. My question to you is, do you believe that, in light of the explanation that you gave us when you started, do you believe that the Constitutional Court judgment somehow it is wrong? And of course, I mean, you can think that the Constitutional Court judgment is wrong. The judgments that are coming from that court, they can be wrong. So don't be afraid to answer that part, if to the extent to which you feel that it is wrong. But in relation to the facts and the law, the way it has been applied, do you think that your approach was correct, and that of the Constitutional Court in particular was incorrect under the circumstances?
You know, it's a difficult issue to answer at the level of courts always differ, or often differ. I wouldn't have given the judgment if at the time that I wrote it, I didn't, and I wrote it after much discussion, certainly with some of the judges that concurred with me. I wouldn't have written it if I didn't believe it was correct at the time. Causation is often a difficult issue, as I think you know, and I thought there was an interruption, and it should be split in the way that I tried to explain it. But that's why we have a higher court, and the Constitutional Court has now said, well, effectively, drawing a distinction or treating it almost like a novus actus in between is not the way to approach it. It is the unlawfulness and what arises from it at the outset, the arrest, before the first appearance, before when bail could have been applied for, and for months and months and months that the matter could have stayed. That the detainees remained in custody. It survives, it affords a remedy in law. That's the conclusion to which they've come, and I unreservedly accept that. That is so. That's how we learn.
No, thank you very much.
It's part of a learning curve.
No, I take your point. The last question that I have for you, I see that you practiced as a senior counsel for a number of years.
Yes, for 8 years.
Yes. And this question, I'm raising it against you, or I'm confronting you with it, not necessarily for you personally, but because, but based on what is happening generally in South Africa, and I'm hoping perhaps maybe there will be some change. My fundamental concern with the practice of law is, we don't see many senior counsels taking on particularly female junior counsel, and in all the important matters that they are dealing with. We look at the Constitutional Court, you'll have three counsel. There will be white male, then perhaps maybe one black person. Majority it will be male. And in most instances, it's rare to see a female senior counsel. They are there, but it's rare to see a female senior counsel being the lead in these matters. In your practice as a senior counsel, have you roped in junior advocates, particularly black people? If you, I'm not sure if you have that perhaps in the top of your head. And of course, as a judge as well, what role are you playing in ensuring that at least there is some encouragement for opening up the space for female advocates?
Our role as judges in promoting particular legal practitioners is obviously very limited. We don't necessarily, or we don't know until very shortly before a matter appears who might be appearing in the matter. The choice of counsel will be that of the litigants. More and more, and perhaps before I say that, my experience as at the bar, as an advocate, you must now please remember, goes back to prior to October 2006. It was a different ball game then, and I'm not suggesting it was the right ball game. I see things have changed. We don't get the opportunity really, although it has happened in the past, that you might find that there's a particular tricky point of law that needs to be argued, and there's a litigant in person, and you will not get the benefit of a full legal argument by just having the litigant in person doing the best he can in a very difficult situation. And then we often approach the secretary of the bar or the chairman of the bar to appoint a member of the bar on a pro amico basis to assist that litigant. That normally is a communication through the judge president or somebody more senior. It happens in very, very isolated situations, as I think you can probably appreciate. Those might be opportunities where in the future we should say, well, we request that a particular female advocate be appointed, or that a female advocate be appointed together with or a more junior advocate of whatever gender or racial group be appointed, because it affords them the opportunity to gain experience, often with a senior. But briefing patterns apart from that are really dependent on the instructing attorney. But I had, for example, an opposed motion this coming Friday in Pietermaritzburg, where I collected the heads of argument quickly on Friday, and there's a counsel signing the heads of argument, and then co-signed by, I've forgotten the name of the person or the two, but as he's appointed, quote, devil, unquote. You're familiar with the term deviling for another advocate. It's rendering assistance, doing research, and that kind of thing. So I'm quite looking forward next Friday to seeing, it's a senior counsel, and with him this devil that he has appointed. I assume it's on a non-numerative basis, but that's the kind of thing that I think can be encouraged.
No, thank you. I think I'm covered.
But as judges, I don't know that we've got too much control over it.
DCJ, quick follow-up, please.
All right.
I know the person who asked the question said it's covered, but that was not the question. That the answer was not to the question asked. The question was, did you brief, when you were still a senior counsel, female lawyers, advocates, other senior advocates or juniors? Did you brief black advocates, seniors and juniors at that time. And in trying to answer that, you said there was a different ball game at that time when we were still practicing. I want to understand that what was the different ball game in 2006 after 1994. So you may want to take us into confidence as to what are you talking about
Yes.
a different ball game.
Yes.
We're not asking about judges choosing representatives. That one we know. But we want to know historically, when you are still practicing, what was your attitude on black advocates, juniors, and female advocates?
Yes. The question had moved on to what judges could do, and I was dealing with that perhaps because it arose last and it was fresher in my mind. The position in 2005, 2006, around there, we didn't generally, or I certainly didn't, and it wasn't at the bar, a general practice of involving or instructing other advocates to appear with you. I think, if I cast my mind back, we might only have had one or two at most female advocates at the bar where I practiced in 2006 or thereabouts. The question of deviling and getting the consent of the instructing attorney that instructs you to involve another person, a black advocate, who, for example, in your case that you've referred to, or in your example, wasn't generally followed at that time. My contribution in that regard consisted mainly, as I said earlier on, in having a number of black pupils, offering the lectures for them to pass for all the pupils to prepare for their bar examinations and to assist them in that regard, and also always, once they start practicing, to have an open door policy of inviting them to approach me and to spend time with them to answer any questions they might have or problems that they might be experiencing.
Have you finished with him, Commissioner Magana? Okay. Commissioner Steinberg?
Good afternoon, Judge.
Good afternoon.
Two questions for you. The first is we all agree that there's no place for public opinion in the writing of your judgments. But the question of the public perception of the judiciary is a legitimate one, and is in fact all over the Code of Conduct. It's necessary for public acceptance of the authority and legitimacy of the courts for a democracy to work. With that in mind, there is concern about the delays that take place in our courts, where respondents or defendants who have access to the resources can string out their cases for years and years, sometimes going on 2 decades, bringing endless interlocutories and then appealing them, and the primary matter gets held over. You are presiding over the SV Zuma matter, and until the last leg you dealt remarkably expeditiously with the many interlocutories before you. It's now once again in abeyance. So I have a specific question and a general question. The specific question is there something that stops a judge in your position from going on with the primary matter while appeals wend their way through the courts? And the general question is, what do we do about the problem? What reform is needed to empower judges to hear cases timeously?
May I, with your permission, just divorce the question from the pending case of State versus Zuma, because there are developments and it's an ongoing case. And I feel a bit uncomfortable. Questions have been asked about it, and they were really dealing with events in the past. They were non-controversial, and I thought I could answer them. But just to avoid any impropriety, may I
accept that, Judge Gold.
Yes, may I deal with appeals generally? Public perception yes, public perception is certainly a very important aspect when one comes to respect for the law and for the public respecting what happens in courts. And I see public perception in that context as courts being required to have a very important educational role, in the sense that you must write a judgment and you must explain as simply as you can, hopefully, why certain results and consequences flow. And if they delays, they result because that is what the law requires, that a particular person, let's say in the context of a civil claim, has a right to appeal, and when he files his application for leave to appeal, then there is a delay. He or she, in a civil claim, might have not particularly good prospects, but one can't just simply deny that right to appeal because you, as a presiding judge, think they don't have particularly good prospects. You can say, well, I refuse leave to appeal, but if then thereafter they petition the Supreme Court of Appeal, which they are entitled to do as a procedural, as a systemic issue, then the delay that ensues until the Supreme Court of Appeal considers the petition is an inevitable delay. But you make a very valid point, and it gets back to the issue that I raised earlier on about possible law reform. Generally, forget about criminal matters because it's a slightly more muddy field, as I tried to allude to earlier on. In civil matters, it's essentially governed in terms of Section 18.1 of the Superior Courts Act. Now, 18.1 says that as soon as a person who's dissatisfied with a judgment files an application for leave to appeal, that automatically suspends the judgment. There's a procedure in Section 18.3 for the other party to apply to court to have that judgment put into operation, notwithstanding the application for leave to appeal. But absent such an application in terms of Section 18.3, the consequence in law, which is the legal principle which I'm required to apply, is that as soon as there's an application for leave to appeal, that suspends the procedure. That essentially, 18.1 essentially accords with what the common law provides. I've often asked, or I ask myself, and I ask it in this context, on this platform, whether we haven't reached the point where when an application for leave to appeal is filed, 18.1 is amended to read, not that it automatically suspends the operation of the judgment, but that it doesn't suspend it, but that it may be suspended in the discretion of the judge. And the reason I say that is simply the following. You can have a big civil dispute that is prepared for months and months and months. Senior counsel, junior counsel, everybody preparing. You run your evidence. It takes 2-3 weeks in a court of law. At the end of the evidence, the judge takes 2 or 3 or 4 weeks or whatever. He researches the law, he or she researches the law. They write a comprehensive judgment, which is a very good piece of work. It seems to accord with the law. It is virtually appeal-proof. It is correct on the law. And what does the disgruntled party do? He can put in a single page where he writes, I appeal to the Supreme Court of Appeal or to a full court on the following grounds. The learned judge, paragraph 1, failed to apply his mind properly to the matter. He overemphasized the importance of let's say the plaintiff's evidence, and disregarded that of the defendant. And that suspends the entire judgment. Hasn't the time come that when we have an application for leave to appeal, it should be left to the presiding judge to say, yes, I do, as the one who wrote the judgment, I know I have reservations on certain points, therefore, pending the appeal, I am not going to let this judgment be carried into effect, but at the same time also, that if it is an appeal that has no prospects, as much as one cannot deny the party the right to appeal and to pursue it further, to petition and whatever to the Constitutional Court, but at least, mero moto, the judge can say the operation of this judgment won't be suspended.
Thank you. My second question is merely, I want to give you an opportunity to respond to the BLA's adverse comment in this way. Are there any particular judgments that you have penned that you would point us to that demonstrate your ability to grapple with constitutional matters?
You know, the comment, sorry, I always get confused now. I always look at the first one. That's the one I must ignore.
The comment...
Yes, no, I have it, thank you. It didn't define or didn't identify any particular judgment. If it had, then I could have given you chapter and verse on what my thinking was. But in every case where there are constitutional rights involved, I obviously am required, and I do weigh them up against each other and give consideration to it. The fact that one comes to a particular conclusion, which a particular commentator might think is the wrong conclusion, doesn't necessarily mean that you didn't consider all those constitutional rights. I'll mention one. I didn't now bring it with you, but there's a judgment that went to the Constitutional Court, in fact, NEC for local government versus, it involved two municipalities. The one was the municipality of Nkandla. There were two municipalities, the other one's name escapes me now, but in both those, a municipal manager was appointed who didn't have the required qualifications to be appointed as a municipal manager. But because of certain internal strife, the person was appointed, and then the NEC subsequently took steps to have them removed in terms of the legislation on the basis of legality, a legality review, that they didn't have the required qualifications. Now, questions arose of the delay because the NEC had taken some time before initiating those proceedings. So here we have a number of constitutional rights involved. You have the municipal manager's right to employment, to follow his occupation. One has administrative rights involved. You have the principle of legality involved, all constitutional values that have to be weighed up. Following Gajima, we also know if you have a review, even if the delay is unreasonable, if it's excusable, you've got to look at all those considerations. I concluded that the delay, if I remember correctly, although a long delay was not unreasonable, that the principle of legality, that having regard to our municipalities, having regard to the state in which some of them are, that a consideration such as whether your municipal manager is properly qualified outweighs those other rights or values of the Constitution. But it's a value judgment. But I engaged in those things. I then concluded it should be removed, went to the Supreme Court of Appeal. I granted leave to the Supreme Court of Appeal. 3-2 judgment. Ponnen was in the minority. I can't remember who wrote the majority judgment. 3 said no, shouldn't be removed. The delay was unreasonable, not excusable. Ponnen said no, legality prevailed. So it showed once again, He had as difficult a problem also, with respect, as I would have had. And then it went to the Constitutional Court, and the Constitutional Court said the delay was inexcusable, and that this person, or these two persons, although they don't have the formal requirements necessary to be a municipal manager, could remain in their positions. But I mention all that, the entertainment value or the value doesn't lie in the result. It lies in the fact that there's one case where all these competing values and rights were being weighed up. And there'd be many other, but from the top of my head, I didn't prepare on this, but what you've asked me,
You've answered the
yeah,
question.
they might not. The person who wrote the report, if he had that particular case in mind, might have thought that what the Constitutional Court eventually decided, or the majority decided in the SCA, was a preferable result to what I and the minority in the SCA concluded. But that's inherent in litigation. Doesn't mean you haven't engaged in assessing the competing values.
Now, I asked the question precisely because I'm concerned about criticisms that are made, which are very difficult to answer because they're non-specific.
Yes.
So I offered you the opportunity to answer in a positive manner, to try and be fair, and you've done so. Thank you.
Thank you for the opportunity.
Any further questions for the candidate colleagues? Colleagues on the virtual platform?
I'm covered. Thank you, Deputy Chief Justice.
Thank you. Yes, is that Commissioner Barnard?
Yes, just confirming I'm also covered. Thank you.
Oh, thank you. Anything you want to bring to our attention before you go, Judge Kwon?
No, nothing further, thank you. I don't think there's anything further. Thank you for your patience and for extending the interview to me.
All right. Pleasure. All right. Thank you. Thanks to you too, and you're excused. You're
Thank you.
excused.
Thank you very much. That's fine.
Okay. Oh, okay. Oh, that's quite interesting. Are you settled, Judge Makaula?
I'm trying to,
No, just relax. You're in good company.
it's not easy at all.
And
Thank you, TCJ.
First, before I start putting, leading the candidate, I should disclose that he and I have known each other since we were young students. We are good friends, but that does not affect anything that happens here. Right. You hold 3 degrees, Judge Makaula, a B.Juris and LLB from the then University of Transkei,
That's correct, that's a correct
and
decision.
a master's from Georgetown University.
Correct decision, that's true.
Did you specialize in any particular field for your master's?
I specialized in international criminal law as well as labor law.
Right.
And I even did my internship on labor issues.
You started your legal career in 1984
That's correct.
as a clerk. I take it that would have been at the magistrate's court.
Yes, that was at the magistrate's court, Mount Frey. I had a bursary, which required us to work during holidays.
And you worked as an interpreter.
Yes, I worked as an interpreter. In fact, I worked almost all the offices in the magistrate's office.
And you rose through the ranks, you became a prosecutor and then a magistrate.
Yes, I rose through the ranks. I was a prosecutor since 1986. I think June moved to legal planning in the Department of Justice and then back to the magistrate's office as a magistrate.
But then you decided to leave public service and did articles of clerkship.
Yes, I was recruited by the late Justice Dugada, who offered to give me the salary I was earning, so I couldn't resist that. And then I went to do my articles with him at DZ Dugada and Company.
And then you practiced as an attorney for some time.
Yes, I started in 1993. I was in partnership with Svile Sandile for 17 years before I was appointed.
You've been a judge of the High Court since 2010.
Yes, TCJ, I've been a judge from 2010.
Okay.
Having acted for 3 years prior that.
How long have you acted at the Supreme Court of Appeal?
I started on the 1st of December, yes, 1st of December or January, I can't recall, but I've been acting since January till on Friday, the 30th of September.
So that was your 3rd term then?
That was my 3rd term, yes.
All right. How many judgments did you produce during your acting stint at the Supreme Court of Appeal?
During the first term, I produced 1. Then the second term, I produced 2. Then this term, I produced 3. The 3rd term.
So you have 6?
I have 6, yes. I have 6 now.
Were you able to keep up with the rigors of the court? How did you fare?
I fared very well. I fared very well. I was able to keep up.
Were you able to deliver your judgments in time within the 3-month period stipulated in the norms and standards?
I was, except for Sitau, which was quite an involved matter. Otherwise, the rest have been delivered within term.
I allocated you the judgment in Sitau.
Yes, TCJ.
And just repeat again why you say you delayed the judgment there?
It was delayed because it was quite an involved judgment. It had a lot of volumes which I had to scroll through, and even I had to go through about, I think the core bundles themselves were about 7 or 8.
I think it's the GCB, well, both the GCB and the BLA are not entirely happy with your candidature. The BLA doubts that you are ready to join the SA at this stage. And then the GCB makes reference to a concern that is not new where you are concerned. It's something that has been raised with you in a previous interview here.
Yes.
That you have a tendency to delay delivering judgments. What do you, or do you want to say something on that?
Yes, I just want to...
They've specified a period that you have reserved judgments for a period ranging from 5 to 7 months.
Yes, Mr. Jane. It's not in my nature to reserve judgments. It depends entirely on the circumstances under which I find myself in. Like, for instance, I've checked on the judgments which apparently the GCB is referring to, and I was able to pull out the roll for that term, which I have in front of me. May I just go through it,
Yes,
Mr. Jane? Yes. During the period of February, which is the concern, I picked up 4 judgments which they were talking about. During that term, it starts on the 10th of February. I was doing duty. The following week, I was doing appeals in Grahamstown. And the third week from there, the 9th of March 2020, I was doing duty as well. And I was able to pick up the roll as well as my book. I pick up no less than 4 judgments during that period. That is the first week on the 10th. And then again, I pick up about 2 judgments on the 17th, the week of the 17th of February. And because these matters which they refer to are quite involved, I took time to deliver those judgments. It was not because they were the only matters which I had, but it is because that there were other matters which I had to attend to as well. And it's not easily done. The JP will confirm that. It's not easily done in the Eastern Cape that you are allocated duty this week, and then the following week you are allocated appeals, and then the third week thereafter you are also allocated appeals. We made a resolution that in the event that a judge has to do duty or appeals, it must be twice in a term, not in succession. Because once you are it's done in succession, you are likely to be swamped. You are going to pick up judgments which are going to swamp you. And even the following term, which deals with the 2020, I think it's 2021. This is for 2020, those judgments which were affected in 2020. Then the other judgments which were affected were, in fact, I've got the here, that is in March 2021. A similar thing occurred. I was on duty in 2 successive weeks.
All right.
And in that event, TCJ, it's not easy at all. I don't take away what they are saying, but it's not easy when you pick up more than 3 or 4 judgments to deliver all of them in time.
All right, let's just go back to your stint at the SCA. You listed 2 reserve judgments as outstanding when you submitted your application. Well, I know for a fact that Stau has been delivered. What about the other one, Diljan?
It has been delivered and it was reported as well. I think Diljan was reported. No, it's Paloi which was reported.
Sorry?
It's Paloi that was reported as a reported judgment. Diljan was delivered on time as well.
It was delivered?
Yes. Okay. It was delivered in term, during term. Mm-hmm. Yes.
Okay. I just want to go back to your judgment writing ability. And I just want you to respond to my question as honestly as you can. Do you believe that you are at a stage where you can write a good judgment without the need to be handheld by the rest of the judges panel around you?
I believe
Have
so.
you reached that stage where you can write a good judgment on your own?
Yes, I believe I can do that.
You have?
Yes.
But that was not my experience in the 6-hour matter. It was a struggle to get a judgment out in that matter.
No.
As I recall, even when senior colleagues had made their inputs up to the stage of conference, when I had already left the court, because I was not there during the conference, and a letter was circulated by one of the senior judges in the panel, pointing out that after the conference where all the final inputs will be made, and the scribe, which was you in the case, has been given all those well, not suggestions, all those edits to implement. Still, the judgment that came out was not correct. It had to be corrected substantially. And that gave me the impression now that you had struggled just to proofread your own judgment. Was that not the case?
It must have been the case, but I think I spoke to Judge Dambuza because I had a problem with my secretary. She signed a wrong judgment. And Judge Dambuza is away.
I'm sorry, just repeat that.
What I'm saying is the secretary sent a wrong judgment. And if you look at it, DCJ, even that judgment that was sent, it did not highlight all the comments which were necessary in terms of colors. Like you normally, as the scribe would be yellow, the others red, but she just circulated a wrong judgment.
But you do understand that at the end of the day, the judgment is yours. It's not the secretary's.
Exactly.
So it is your duty to ensure that what is circulated to the rest of the colleagues is the right thing.
Exactly. It is my duty. And if I'm not computer literate, unfortunately, if she says she signed the right judgment, and then it is discovered that it's a wrong judgment, to an extent, what we did with Judge Dambuza, or Justice Dambuza, is that we changed the secretary and used her own secretary. Just because of the same reason I'm talking about, because she kept on making mistakes after mistakes. And then Judge Dambuza suggested that we should use as Bongile, that is her secretary.
Well,
and in fact, eventually it is her, if you look at it, who eventually ran with the judgment until it was delivered. Because the secretary I was allocated was really battling.
One last question from me on this aspect. I'm not talking about you being computer literate or not. I'm just talking about making sure that your secretary actually sends out the right document, and you don't need to be computer literate to be able to tell that.
In that,
especially when you know that they are struggling, they are lacking here and there. When it comes to a final draft of a judgment.
In that instance, DCJ, once you push that button, because I was with Judge Dambuza even at the time, once you push that button, it's gone. And that is why I pleaded with Justice Dambuza. And in fact, she insisted that let's rather not use her and use her secretary. She was equally frustrated as I was.
All right. Lastly, you have also listed 4 parted matters. Those would be in your division in the Eastern Cape.
Yes.
How far along are they?
There are 3 of them are civil matters are going to be argued. This next week, I think it's next week in October. Second week of October, I think that it will be next week. The other one is a criminal matter. It's coming, I think, on the 28th of October. It's for argument, as well as them having filed an application that the prosecutor must recuse himself.
So you do attend to these matters during recesses?
Yes, I'm going to attend to them even starting next week, Monday.
All right. Thank you, Judge Makaula. Colleagues, do you have questions for the candidate? Commissioner Nyambi, President Betse Commissioner Steinberg. All right. Commissioner Nyambi, go ahead.
Thanks, DCJ. Afternoon, Judge Makaul.
Afternoon, Commissioner Nyambi.
It's only one question. It's a follow-up to the one that has been raised by the DCJ about that computer literate judgment.
Yes.
As you are not going to be privileged to be part of the closed deliberations when dealing with this issue. And DCJ was part of the people that dealt with that case. That dealt with the case. As somebody who was not part of it, I'm more confused the more you're doing the explanation. Maybe if you can clarify why she is having that wrong information, but she was part of the very same case.
May I, with respect, ask which wrong information?
The wrong judgment that was submitted. We are saying it's the wrong judgment. It's saying, no, it was pen-and-peated. There were some challenges in terms of that judgment.
What happened is this, Commissioner Nyambi. The secretary I was allocated attended to the corrections. The corrections were there, the judgment was there. And what happens in the SA is that if you're dealing with one judgment, it gets circulated on numerous occasions. Not once. You can find that you circulate it 3-4 times a week. So what happened in this instance is that the judgment was, I received comments from colleagues. And then we adopted the comments. And then instead of her accepting the comments, she sent the judgment raw as it is, with the comments still in those colors without them having been accepted. Because once you accept them, then you won't see the colors or the comments made by your colleagues. I don't know whether it makes sense or
No,
not.
are you not the one that's supposed to make sure that what is sent by the secretary, it's what we have finally approved that she must send?
Yes, I am.
So where is the confusion still, if that is the case?
The confusion is that she sent a wrong judgment instead of sending a correct judgment. Because once you email them, you don't send a hard copy.
Let me put my last one. Probably as somebody acting in the SCA, what might be the challenges that are in the SCA with your experience?
The only challenge which I had is the question of the secretary. The only challenge which I had, and Judge Dambuza can attest to that. That's the only challenge which I had when it came there, when I came to the SCA. Other than that, the rest, it is okay. I worked very well at the SCA. Collegiality is there. Other than that, I had a challenge with the secretary.
Why was it not properly explained to all the other colleagues that were part of the very same case so that they are on the same page? Because we are picking somebody that is not part of us now, but we've got a DCJ that was part of that process and has got a different understanding so that there is no confusion.
I may have made a mistake because then I should have maybe circulated something to the panel. I may have made a mistake. It's an oversight on my part, surely. I should have explained to them. The only thing which we did is just we shifted and then we used Judge Dambuza's secretary because I was not making headway. I accept, you correct, I accept that I might have made a mistake in that regard.
Thanks, Judge Makaula. Thank you, TCJ.
Sorry, before I move
Follow
on, I just to be fair to you, Judge Makaula, because I will be talking about this at deliberations, and I don't want to mention facts there that I did not put to you here. I omitted to mention just one important thing, that the reason that I could not attend the conference of the final draft was because I had to leave for the Constitutional Court. The matter had been set down for conference, and you had gone home, and on the night preceding the day of the conference, I got a call from my secretary telling me that your secretary had called her to tell me that you could not make it to conference that Monday afternoon. She called me on a Sunday because you had gone home and you just would not be available. And I had actually been stunned by that because it was an old judgment. It had taken time just for the first draft to come out. And there had been, all sorts of dilly-dallying. And now something totally unprecedented for a scribe of a matter when there is a conference to go home and not come back on a work day because conference was set down for Monday afternoon at 4 p.m. Can you just explain about that? I know that you have an explanation, but I'd like you to make it here.
I received a call from from my secretary on Sunday that there's a conference on Monday at 4. By then I was home and travel arrangements had been made. And my flight was arriving in Bloemfontein at 6:15 that Monday. I made a mistake and I admitted that mistake to both yourself. I'm sorry to say that
Yeah, that's fine.
DJB, yes, no, DCJ as well as AP. That I made a mistake. I should have called you on Sunday. Immediately when I got this information, I should have called you. I realized my mistake early on Monday morning, and I tried to call you. And having tried to call you, I even sent an SMS to you, apologizing. It was an error on my part. I accept it even today. I made a mistake, and I regret making that mistake.
Had you asked for permission to be away from the court on the Monday, which was a work day?
Not at all. I apologized for that, and I still apologize for that.
Last question, could you not have driven from your home back to Bloemfontein?
I could.
In the early hours of the Monday so that you could be there at 4 p.m.?
I could.
Thank you, Judge Makaula. Commissioner Malem?
I'm covered.
Minister?
Thank you, Justice DCJ, and afternoon, Judge Kaula.
Judge, good afternoon, Minister.
Yes, I'm also a bit confused on this issue of blaming the secretary. I want to understand, because my understanding is that even for a director of a firm, whatever that the secretary does, that person must take responsibility. And the person of your caliber as a judge, is it not a fact that if the secretary has sent that it's you who must take responsibility for whatever that you have sent, whether it's a mistake or not?
I accept that, Minister, wholeheartedly. I accept that I am responsible. I was merely explaining what happened. I really honestly accept it, and I apologized for it.
Yeah,
I can't run away from the fact that I am the responsible person. I am the person who has to take the fall.
Okay, no, I think now I'm clear now. The second one is on this issue of that you have just declared of being computer illiterate. Are you planning to take some courses, or is there anything that you're doing to improve this situation? Maybe you could explain today.
Yes, I'm really doing it now. I really am trying to edit the judgment and do all those things. I am taking steps to learn that.
Oh, okay. No, thank you, DCJ.
President Betsy.
Thank you, DCJ. Good afternoon, Judge Makaula.
Good afternoon, AP.
I'm looking at the feedback from the GCB concerning your reported judgments.
Yes, it is AP.
You have been a judge for 12 years.
Yes, AP.
And they've listed only 6 judgments that you wrote which found their way to Shooter's law reports and Butterworth's law reports?
Yes, AP.
Is that the sum total of your judgments that were reported over a period of 12 years?
Nope, it is not AP. It's only those which I referred to my in my questionnaire. There are more than that. The reported judgments are more than that. That I have. I'm trying to find a repository which I was given by the researchers regarding those judgments. In fact, there are more than that, with AP.
Because the GCP says we have considered the candidates' reported judgments.
Yes.
And they list only 6 judgments.
I thought those which they listed are those which I touched.
But you were given that document from the GCB.
Yes, I was.
And you have had it for quite some time, knowing that you'd be sitting there today.
Yes.
Let's deal with this Sikau judgment, because it appears that it is an albatross around your neck.
Yes, it is.
I'm hearing for the first time that you had endless difficulties with your secretary at the SCA.
Yes, I didn't report it to you.
You are the scribe. Many drafts float around. Is it not your responsibility as the scribe, once your judgment has been to conference and further edits take place there, to ensure that the judgment which you circulate as the final version pre-delivery is the one which receive the attention of every member of the bench at conference?
It is AP.
Did you then tell your secretary that this is the final version of my judgment, and this is the judgment that I now want you to circulate and send to the other members of the bench for them to have a preview of the judgment which will be delivered in a day or 2 days or 3 days' time?
Yes, I did, AP. I told her, and then instead she sent a wrong one.
Despite the fact that you had identified to her which judgment to send?
Yes, AP.
Then a conference note is issued on a Friday, convening a conference in the afternoon of the following Monday.
Yes.
And it is now common cause that you did not attend that.
Yes.
And the reason is that you had gone home for the weekend.
Yes, AP.
And that you had problems with flights.
Yes, AP.
But you knew even before you left Bloemfontein that you wouldn't be able to get to Bloemfontein on Monday, and that you would be away from court on Monday.
Yes, AP.
And you didn't find it necessary to make proper arrangements with the acting head of the court.
That was my mistake, AP. I made a mistake.
Is that not a manifestation of disrespect to the institution?
I wouldn't say so, but AP, that I would go out of my way. I haven't done it in 13 years I've been a judge. I haven't shown any disrespect. And even when I came to your chambers to explain, I was hurting. Because it was a clear oversight on my part. And I was hurting to an extent that, I may mention this, to an extent that you even said that I should not punish myself that much. I was hurting because I don't want to appear in any sphere, and I haven't shown any disrespect to any elderly person for that matter, let alone to those who are above me at work.
And before you left for home, you had an occasion to accompany one colleague who had informed you that she wanted to come to me and remind me of the arrangements that she had made with me.
Yes, AP.
That she would be going home for the weekend.
Yes, AP Tina, I did.
And yet it didn't occur to you that you didn't get a flight on a Sunday to be able to be at work on Monday.
If I remember well, the itinerary had not come out by then because I decided late to go home on a Thursday, but I don't deny that. I don't deny it at all.
When you were being asked questions by the chair of the commission, you told the commission that you can write judgments on your own and you are satisfied that you've got what it takes to be a judge of the SCA. Did I hear you correctly saying that?
Yes, I'm of the same view that I can write judgments on my own.
Notwithstanding the many difficulties that were raised with you by the other members of the bench with whom you sat in this matter.
Come again, AP?
Despite the fact that there were concerns raised by the other members of the bench in this matter about the quality of the judgment that you have produced in that matter.
No, I haven't heard anything from the panel. Honestly, I haven't. I've not heard any of the panelists. Because if I remember well, it was the DCJ, it was Judge Dambuza, it was myself, it was Trevor, Judge Govan, and Makhoka. They never raised any issues with me.
And all of them were happy with your first draft that you had circulated?
It had typographical errors, which they
No, on matters of substance.
No. The only person who raised issues of substance is Judge Dambuza. In fact, she inserted 2 paragraphs. The rest, it was cosmetic stuff. Then she only added 2 paragraphs.
So do I understand the position to be that in relation to all the judgments that you have written at the SCA, comments that you have received or you received from the other members were cosmetic changes only?
As far as I can recall, that is the position. Not unless maybe AP can refer me to a judgment. But in this matter, I'm certain. I am positive about this matter.
There's a draft that you circulated last week.
In respect of which matter, DP?
Can you remember the name of the matter in which you circulated a judgment
Circulated?
that I had assigned to you to write?
Yes, the one you assigned to me to write?
Yes.
It's Placha Haumet, I think. Let me check. Yes, the Placha Haumet judgment. That's the Placha Haumet judgment, Mellet judgment. Then in respect of that one, I've only received from Clive.
You received comments from
From
one of
Judge
the
Plaskett.
members of the bench.
Yes, from Judge Plaskett. Then I received them, I think, on Friday. Friday morning.
Would you say that the suggestions that he gave you are merely cosmetics or are matters of substance?
I wouldn't say they're cosmetic because what he did is instead of quoting sections, he paraphrased those sections. That's how I viewed his comments. And that's what he said to me because he came to my chambers. And he explained that, Mandela, what I did, instead of you referring to the text or to the contract itself, let's paraphrase it. And then I said, okay, I'll wait for other people to come up with their suggestions.
Thank you, Judge Makaula. That's where I'll leave it.
Thank you very much.
Thank you, Deciche.
Judge Makaula, it pains me to do this. I'd hoped that we'd not go this far. But I have to place this on record. My conscience won't rest. Still about this 6-hour judgment. The colleague, because I was the presider in the matter, it was my responsibility to ensure that the judgment is produced. So I kept checking with you as well when the draft would be produced, because I was worried that I'm leaving the SCA, I'm going to another court, and I told you that I don't want to leave leftovers. I want my desk to be clear when I leave Bloemfontein. Yet the judgment was delayed. Now you told me that you had asked for the help of one of the senior judges in the panel, which was fine. I had no problem with that. And when I did speak to that colleague, they told me how they had struggled with the first draft you produced, and that the main concern was not about the substantive issues you had got wrong, but that you could not even get the facts right. But then it was a heavily fact-laden matter. I understand that. It was a big matter. But there was that concern that at least insofar as just setting out the factual background, you should have got that right, that much. And that was the concern of this colleague. And I understood throughout that, but what bothers me now is this, I don't want to get, it's more like acting on hearsay now, but I had no reason to disbelieve a colleague who was being helpful when they told me what they told me. And I just want to place that on record, so that it's out there. You may respond or not. You've already put your version that it was just typos that were affected to the draft. And I may just add, lastly, I promise I won't say anything more about Stow now, that even when, after all the rehabilitation that the other colleague had said they'd done to the judgment, when it came to me, when it finally came out, I also made substantive suggestions to your judgment. Speak about what I myself did. and you know that.
Substantive.
Yes, yes, I did, and I have proof. Maybe our definition of substantive and cosmetic are different, but I know that I made, it was a decent draft, but I still made substantive suggestions to that draft. I'm going to leave it there. You may respond if
You know,
you wish.
it pains me. I'm pained. It really pains me.
So am I.
For someone to say that I could hardly produce the facts of an ordinary history which I've got.
That's the power coming back.
I still have, sorry. I don't know, yes. I still have the draft papers which are handwritten now in manuscript. I still have them, even now. I haven't destroyed those manuscripts. So it really hurts me for someone to say that I could hardly deal with the facts. And if you remember well, DCJ, I kept you posted. I sent you SMSs telling you the stage at which the judgment is.
All right. Thank you, Judge Makolo. We'll leave it at. Commissioner Steinberg, had you raised your hand at some stage?
I'm covered, thank you.
All right. Commissioner Matolo Lepu.
Thank you, Deputy Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner Lepu.
Mine is just that I know that you explained the issue of the secretary, but do you think, because I don't want to remain with not understanding whether your secretary maybe needs training or there's something, because because there was something wrong with, because if the secretary sent a wrong judgment, she must have gotten it from you. I'm not sure. I still need that explanation.
She's more than 10 years, as I understand, in that court. She's more than 10 years. And Judge Tambuza, I cannot lie, Judge Tambuza is aware. The only problem I didn't do is to tell Judge Bates. Justice Bates or AP Bates, I'm sorry to say that. But Judge Tambuza know about the problem which I had with her. And to be honest, and if we speak honestly, that is exactly the reason why I changed and used Sibongiseni, who is the secretary to Judge Tambuza. It's because of the endless problems which I encountered from the secretary. And even the secretary of Judge Tambuza, she knows exactly. Because each time she sends a draft to her, then it comes back wrong. It's honesty. I can't be lying about this.
Just to follow up, Deputy Chief Justice, I'm trying to assist that maybe the secretary needs upskilling, or, we can't leave him or her if she goes to an extent of making your life difficult. Should we not, because at least the head of the court is here, maybe she needs assistance.
And even in my absence, they can go to Judge Tambuza. She will be explaining exactly as I say.
Thank you, Deputy Chief Justice.
Thank you, Commissioner Dolodleko. Commissioner Lucas?
Thank you very much, TCJ. Good afternoon.
Good
evening,
Commissioner.
Judge Makola.
Good evening, Judge.
I should say I was extremely concerned when the issue was about the secretary. And I became more concerned when the head of the court was never informed about your challenges. Now, the first question that I want to ask you, as a very senior practitioner, as a judge or as an advocate or whatever you or say a jurist, you are experiencing a problem. How do you solve it? What is the procedure at that court for resolving such an issue? That is my first question. Secondly, I get more confused because when you first started to say that there is a challenge with the administrative staff, you said that she took the report and you gave her all the amendments and they was never introduced into the document. Now at the end you say only 2 paragraphs.
Yes.
So I maybe it's English, I don't know. But also I'm taking into account of what the DCJ was saying, that some of them also made some amendments. But when you were speaking, you said all the amendments. So for us, it seemed as if there was quite substantial amendments to the issue or to the report. Now, and then in the middle, you say only 2 paragraphs by 1 person. And it's not, I mean, I don't want to seem as someone that are taking sides, but you are confusing me because I am not a legal person, but I'm getting confused because what is the procedure? And if there is no one else that amended, or if someone have amended and really you feel it is true, I don't think it will die if you say it is even yours that was not affected. But if someone should say, many of us that are sitting here have been heading offices before. And we know if your secretary works on a document, the last step before it goes out of your office is to make sure that what is going out of your office, you can identify with it. So it is, in actual fact, I'm very disappointed that the secretary is being now put in front of us in such a high-level panel where the whole country is watching you. You are actually shifting responsibility. That is my view, and you can dispute it, but you are shifting responsibility. And also, you have, in actual fact, you are aggravating the situation because in the first instance, I was like so perturbed with the secretary that can take a whole court report and not affect the amendments before it was sent out. Now you are saying it's just 2 paragraphs. Now it comes back to the fact that you are now saying others didn't make amendments. What is the true story? Please, Justice Magola, assist us.
Yes, the true story is this. The secretary sent a wrong judgment. I should have seen to it that she sends a correct judgment. I am not shifting the blame to her. I am responsible for that judgment. I am responsible for the fault she has done. I am not running away from that. Regarding the judgment, I was only responding to the DCJ when she was saying that substantial changes were made on that judgment. The judge who is Judge Dambuza, when I sent the judgment to her, added 2 paragraphs and some type of attentions which I had to attend to. I don't know whether I answer your question.
I mean, what can I say? Thank you, DCG.
Commissioner Nukes?
Good evening, Justice Makaula.
Good evening.
3 things that I just want to focus on. 1, in respect of the comments that have been made against you, including those of PLA and GCP, all those bodies, they support the nomination. I've not seen a person or an organization that say you are not you are not fit for the SCA. Like the question from there, would you regard yourself that would you say you are an all-rounded person who would qualify to be judge of the SCA?
I would suggest that it's a subjective thing, and then subjectively speaking, I am. But viewed objectively by other people, they may come up with something different. But even the comments, the judgments themselves, the comments of the GCP, because the more detailed report is that of the GCP. It is more detailed. It comments on the judgments which I've attached. It comments on the quality of the judgments. It comments on any other aspect of the judgment, and even the other bodies.
Yeah.
They comment on the linguistics, on the language, on the manner in which those judgments are written. But
And this
hence,
one,
I was taken aback when it was said I could not even summarize the facts.
I'm looking onto the BLA. If you notice, the BLA had two comments. The one is from the office of their president,
Yes.
and the one is from the office of their secretary.
Yes.
I'm not too sure whether these two, in the respect of you, I haven't checked properly. Do they speak to one and the same thing
No.
about you? Because it seems as if the president gives a different comment whilst the secretary gives a different comment.
No, they don't. The secretary gives. I think, as I understand, the comment of the secretary is that this was a matter which involved prescription. Then I should have I should have seized the opportunity of declaring the section unconstitutional, and then I am not qualified.
Lastly, TCJ, I'm sorry, the last question. Look, I agree with the DCJ and the president of the SA in respect of questions relating to attending conference
Yes.
and other matters.
Yes.
But where my difficulty is in respect of comments into your judgment. In the SCA, you sit 5 judges. These comments, I'm not too sure what is their nature. Do they relate to the language used, the question of punctuations in the judgment? Bearing in mind that people do write assignment, 5 of them in one class, taking from the same book, but they will get different marks. I'm not too sure. I mean, what my question is, mainly is, in respect of the outcome of that judgment, that you did one of those judges come differently, or somebody even decided to write a dissenting to your reasoning on those judgments?
What pains me the most is this. If a judge, like we are 5, has made substantial changes, the judgment would not have come out in my name only. That's how I understand the procedure. It would never have come out on my name only, because the contribution he would have made would be substantial. And therefore we would, like for instance, we were sitting in a matter with Judge Bonan as well as Judge Patswana. Judge Bonan came back with substantial changes to the judgment. And when we were conferencing, he said, because I've made these judgments, these comments, I think we should, both of us, be the authors of this judgment. Rather than being me or be you, then both of us should be. So I would have expected that if that be the case in the Stau matter, then surely I would not have come out as the only scribe or as the only author of that judgment. And I'm sorry if I may comment if DCJ allows me. Regarding the matter which AP is asking me about today, that there was a comment or a judgment which was referred. In that matter, it's just that, I just want to explain this. Judge Plaskett came to me with his own suggestions. We are a panel of 5. He came back with his suggestions. I haven't received 4. And I did not accept those changes which Judge Plaskett came up with. I did not. I said, okay, Clive, put it on my desk, then I'll wait for the other comments. Thank you very much, DCJ.
All right. Any further questions for the candidate colleagues? Prof?
Thank you very much, Deputy Chief Justice. Good evening, Judge.
Evening, sir.
I think let's talk law now,
Yes.
and just take a break from the issues of the court itself. There is a judgment. Let me just make sure. Yes, there is a judgment that you penned, AR versus HR. It is a judgment, it's an insolvency law matter where
AR versus?
HR.
I don't have it.
You don't oh.
I don't
then
have
it will
it,
be a
I'm
little bit
sorry.
unfair.